As of the 31st of January, the country's law enforcement will have additional tools around DNA collection and usage in capturing and prosecuting criminals. This after President Cyril Ramaphosa announced the commencement of parts of the Criminal Amendment Act. So this means that a suspect arrested and charged with a Schedule 8 offence will be required to provide a DNA sample, which will be uploaded onto the National Forensic DNA database. To expand on this, we're joined by Vanessa Lynch, DNA Project founder. Vanessa, thank you very much for joining us this afternoon. So what does the current landscape look like where this issue is concerned in South Africa, and what does this latest development mean in relation to it?
Hi, Dudu. Thank you for having me. Well, up to the 31st of January, when this proclamation will become effective, there's been a discretionary provision that enables the police to take a DNA sample from a Schedule 8 arrestee only on a discretionary basis. The reason that this is another weapon in the arsenal of crime-fighting tools, so to speak, is because it now becomes mandatory, and that is that all arrestees of Schedule 8 offences, and Schedule 8 offences are a pretty wide range of offences, from very serious violent offences as rape and murder right down to burglary, and it means that every single arrestee must have their DNA sample taken. And the reason it's really powerful is that the greater the number of known profiles on the database, the greater the chance of us linking them to unknown profiles from other crime scenes. And we really have seen already over the years the effectiveness of the National DNA Database, and this will just give it greater might, so to speak, to identify serial offenders.
And that's just it. So this move, some have termed it rather a big step towards solving and preventing crime, especially sexual offences. Why did it take so long?
The reason that there's been a delay from the time that the DNA Act, which is its colloquial name, from the time it was passed in 2015, is that there weren't enough police officers at that time who were trained to take DNA samples from all arrestees. So what happened is that once there were enough trained police officers to enable every police station to have the capacity to make this mandatory, the Detective Services says we now have enough trained police officers, therefore we can make it mandatory. So that was what we were waiting for, and it's very encouraging to see that the President has recognized that this is an additional tool, that now that the Detective Services are ready to take samples from every arrestee, that they actually have made this particular provision operational. And it's a great start to 2022, and I hope that it really does link more serial offenders, specifically in respect of gender-based violence cases.
Right. As you speak, I wonder whether we should be cautiously optimistic, especially when you speak on the issue of capacity and the training of police officers. The police minister last year in May talking about a backlog at forensic science laboratories standing at over 200,000 cases.
Correct, and I think that we must be mindful of the fact that this is going to obviously put additional burdens on the forensic laboratory. However, since that time, they've been providing funding to the forensic science laboratory. All of those contracts have actually been fulfilled. I believe that there's been almost 80,000 cases that have been dealt with since that time. They have a zero backlog date of 1st of November 2022. And I think that whilst there is still a backlog, they are definitely making inroads into the backlog. And with reference samples, which are these known, very simple buccal samples, they are looking at private-public partnerships, which will again increase the capacity of SAPS. So the good thing is that all of these things need to happen in parallel. We can't wait for one to be completed in order for another to be completed. The fact that they are dealing with everything simultaneously means that ultimately we will have a fully functional system, hopefully, and that they are trying to address all of the different areas that need to be addressed in order to really capacitate our police services.
I guess to underscore the point of just how significant this is, the Correctional Services Minister last year confirming that over 96,000 Schedule 8 violent crime offenders were released on parole in 2016 without submitting DNA. So I guess this piece of legislation will go a long way in correcting this?
No, it's actually a completely different piece of legislation. This one is just for arrestees. The legislation you're speaking about, we're actually still awaiting the Parliament to pass that. And that is a very strange, I don't know why there's been a delay, because currently convicted offenders are released without having their DNA sample taken because that bill hasn't been passed by Parliament, whereas a victim of rape or an arrestee who hasn't yet been convicted must have their DNA sample taken. So it's the strange anomaly we have in the law, and we're certainly still fighting for that. And I hope that the media keep tabs on that, because we can't allow that to continue throughout the year. We cannot allow DNA samples not to be taken from convicted offenders, because we have a high reoffending rate, and it's a very important population to have on our DNA database.
That is strange. So this fight, what does it include, and how do we capacitate ourselves to call for more accountability or change?
Well, last year, towards the end of last year, Cabinet did approve we call it the Convicted Offender Amendment Bill, which allows for convicted offenders to be sampled. But this still has to go through Parliament, and we are waiting for that, for Parliament to announce that it actually is before the Portfolio Committee for Police. As soon as it's before them, they will then have to adjudicate on it, and hopefully it will be fairly simple, because it's a simple amendment. And the moment that they have approved that, it will then go through to the National Assembly and the various parliamentary divisions in order for it then to be proclaimed operational by the President. So again, it's just pressure. It's keeping our eye on whether this is in fact happening. And again, it's a very, very important piece of legislation that we need to ensure is enacted, because many offenders can be linked to cold cases, and they shouldn't be released and allowed to be able to go back and commit violent crimes again.
Where are we seeing examples in the world where this is working seamlessly?
Well, I don't think any country can say that things happen seamlessly, specifically if they have issues with crime. But certainly, throughout Europe and throughout America, and in some of the more developed forensic countries where they've had a forensic DNA database for a fairly long period of time, they're actually showing that the DNA database has a deterrent effect, in that it's so functional and it's having such good effect that it's actually deterring criminals from effecting crime. We're not quite there yet, although that is somewhere where we'd like to be. But interestingly, the very first population that they normally put on a DNA database when passing legislation is in fact the convicted offender population, because they have the least amount of rights, so to speak, in terms of a constitutional dispensation. So we are seeing that throughout the country, throughout the world, every country which has DNA legislation, they start with the convicted offender population. So this is something that South Africa have almost turned on its head. We should be starting there and then going to, the other indices in terms of where we collect profiles. And certainly I hope that this year we will be able to really, keep up with the rest of the world, so to speak, in terms of populating our database with the right people in order to deter and detect criminal activity.
I wonder, Vanessa, are you part of, consultations or talks or processes to get this project right at least?
Well, the Action Society, which is an NGO, issued a letter of demand against the government last year. Such, was the seriousness of this, to say that this particular section of the Act, which used to be in the DNA Act, but it expired, they had 2 years in which to collect DNA profiles from all convicted offenders. It was so important that they thought that 2 years would be the right amount of time to get all of the convicted offenders on the database at that time. When that time period expired, all the government had to do was simply extend that time to collect DNA profiles, which they didn't do. So the letter of demand was issued, and in response to that, the Cabinet approval was procured for that bill. But now there needs to be, again, another push to say, well, if this isn't done, maybe the Action Society and other NGOs and civil society generally need to put additional pressure on government to say that maybe a decree of court would be appropriate at this time in order for this bill to be pushed through Parliament.
Much thank you to Vanessa Lynch. She is the founder of the DNA Project.